Good to go. Good morning, everybody. Hello. And welcome to day 2 of the summer school. And I hope everyone is ready for another full day of discussion. So we have a panel of 4 speakers this morning. And we are going to kick off with Hege Orefelen, and who will be the first speaker. And we will keep all Q&A until the end of the 4 speakers, one which will be via video link. So, by way of introduction, Hege is a Norwegian jurist and survivor of forced psychiatry. She holds a Canadian Science degree in analytical chemistry and a master's degree in human rights law. She's currently working on a PhD on the right to self-determination, legal capacity, and free and informed consent to mental health interventions. She has a range of experience in the area and, amongst other things, is currently coordinator of the pro bono project of the ICJ Norway, bringing cases to courts with claims that forced psychiatric interventions violate human rights and seeking reparations. So can you all welcome Hege, please?
Thank you. Good morning, everyone, and thank you for inviting me. I have wanted to join the Galway Summer School for many years, and I'm so happy to be here this year. As was said, I'm currently doing my PhD here at the Center for Disability Law and Policy. As part of my fieldwork, I am carrying out court observations on non-consensual mental health cases before the Norwegian appeal courts and the Supreme Court, cases where the applicants are alleging human rights violations involving disability-based denial of legal capacity. So I will talk about issues related to legal capacity within the framework of gender and disability justice, and I will focus on a few issues for discussion that I think constitute important and urgent challenges. In particular, I will focus on disability justice for people with psychosocial disabilities and on ending psychiatric coercion, which is the main field I have worked within for many years. As a queer woman and a survivor of forced psychiatry, gender and disability justice, right to legal capacity, and freedom from coercion are issues very close to my heart. Before I start, I just wanted to say that I was so touched and inspired by the keynote yesterday that I went back to my hotel and rewrote my presentation for today. For me, it was such a powerful moment when it was said that we should not flee from our experience of being vulnerable. That struck something in me, a feeling of liberation. It is a strength if we dare to be vulnerable, dare to bring our own experiences and perspectives, not only the legal and professional ones, but also those experiences we have collected through years of human rights advocacy and through our life experiences of coercion, violence, and oppression, and of being deprived of fundamental human rights. As it was said yesterday, it is liberating to be able to name the oppression. This human rights battle is taking its toll, and I think by coming here yesterday, it became very clear to me that what is keeping us up is each other. So, after this very long introduction, I will start by saying a few words about legal capacity within the framework of gender and disability justice, before I move on to talk about some specific issues in this regard, and lastly, I will give a few concluding remarks. So what do we mean when we talk about gender and disability justice, and why is legal capacity such a fundamental aspect of that? I will rush through this very briefly, as the topic has already been and will be covered by others. Gender and disability justice, the full equality between women, men, LGBTQIA+, non-binary people, and other gender minorities in all spheres of life, non-discrimination and equal rights of persons with disabilities, and the intersectionality of different marginalized identities. Disability justice centers those historically most excluded groups. Gender and disability justice also includes remedies and reparations for rights violations and harms suffered. To make one's own decisions and choices is a core premise in life. Self-determination is fundamental to realizing all human rights. The CRPD set forth the right of persons with disabilities to make their own decisions and to control their own lives on an equal basis with others. Legal capacity includes both the capacity to hold rights and the capacity to exercise rights. Persons with psychosocial or intellectual disabilities are particularly exposed to paternalistic legislation and practices restricting the right to self-determination. Such practices include deprivation of legal capacity based on actual or perceived impairments and rejection of the person's will and preferences as labeled incompetent to make decisions. Examples are legislations authorizing forced treatments, mental health detention, and other non-consensual practices. A person's disability and/or decision-making skills are not a legitimate ground for denying his or her legal capacity or lowering his or her status as a person before the law. The CRPD committee has spoken clearly in its General Comment 1. Article 12 does not permit such discriminatory denial of legal capacity or substituted decision-making regimes, but rather requires that support be provided in the exercise of legal capacity, and that such support must respect the will and preferences of the person concerned. I will move on to talk briefly about reproductive justice for disabled women. And this is another area where persons with disabilities, and especially women, are at risk of legal capacity restrictions and violations of the respect for physical and mental integrity. And both the CEDAW and the CRPD committee have made recommendations calling for the protection of women with disabilities from forced sterilization and for these practices to be abolished in law. The UN Special Rapporteur on the Rights of Persons with Disabilities has classified forced sterilization as a pattern of systemic violence being carried out on women and girls with disabilities, causing irreversible harm under the guise of best interest, and has called on states to immediately repeal all legislation allowing for the administration of any procedures impacting on the sexual and reproductive health and rights of women and girls without their free and informed consent. Still, forced sterilization and abortion is being carried out around the world. In Norway, women with psychosocial or intellectual disabilities can be subjected to forced and non-consensual abortion on the application of a guardian. The woman's consent needs only to be obtained if it may be assumed that she is capable of understanding the significance of the operation. Also, for sterilization, substituted decision-making can be applied. According to Norwegian law, sterilization requires consent from a legal guardian when a person is deemed to have a serious mental disorder or a serious intellectual disability. And a legal guardian can apply for sterilization without the person's consent when the person is deemed not able to make a decision about the intervention. The CRPD recognizes that women with disabilities may be subject to multiple and intersectional forms of discrimination based on gender and disability and are often denied control of their reproductive health and decision-making. I will move on to 4 psychiatric interventions and the intersection of disability and gender in that regard. Grave human rights violations happen in mental health settings. Deprivation of liberty can in itself be harmful. Indefinite detention is especially harsh and commonly practiced against persons with psychosocial disabilities. Violent medical practices like forced electroshock, forced drugging, restraint, and solitary confinement constitute discriminatory and harmful practices that can cause severe pain and suffering, as well as deep fear and trauma in its victims. These 4 psychiatric interventions meet international definition of torture standards and can cause irreparable damage to life and health. 4 psychiatric interventions violate the equal right to legal capacity, to liberty and security, to respect for physical and mental integrity, to free and informed consent to medical procedures, and to be free from ill treatment. The CRPD committee has repeatedly, in its concluding observations, urged state parties to ensure that all mental health services are provided based on the free and informed consent of the person concerned, and that laws permitting involuntary treatment and confinement are repealed. States parties must respect the legal capacity of persons with disabilities to make decisions at all times, including in crisis situations. In medical settings, we know that some forms of intrusive medical practices, like, for example, electroshock, is disproportionately affecting women. The CRPD committee has expressed concern about the use of non-consensual practices in psychiatric hospitals and institutions, such as the use of net beds, electroconvulsive therapy, straps and belts, solitary confinement, and drug treatment, and the fact that some of these practices are used more on women. As described in the general comment on Article 6, institutionalized women and girls with disabilities are at higher risk of violence than men and boys with disabilities. Also, some practices can be especially re-traumatizing for women with previous experience of sexual or other violence, like to be put in restraints or being held down while your underwear are pulled away to forcibly inject you with psychotropic drugs. The UN Special Rapporteur on Violence Against Women has acknowledged forced institutionalization and forced intake of psychotropic drugs and other forced psychiatric treatment as violence against women and girls with disabilities. Various research show that a large number of women and girls in psychiatric units have experienced violence or abuse earlier in their lives. We often see violence against women with psychosocial disabilities starting with sexual assault or other forms of gender-based violence and ending with forced psychiatric interventions or other forms of disability-based violence. When the Norwegian Center for Violence and Traumatic Stress Studies did a mapping of an acute psychiatric ward, they found that more than half of the patients were victims of sexual abuse. In the mental health system, their experiences are often ignored or marginalized by a system that asks what is wrong with you, rather than what has happened to you. Instead of having the abuse addressed, the women are given a psychiatric diagnosis. Labeling of women's reactions to violence with psychiatric diagnosis has a long history in psychiatry. So has violence and coercion as a response to women's reactions to trauma, violence, and abuse. As female trauma survivors earlier could be diagnosed with female hysteria and forced into asylums to undergo surgical hysterectomy, women of today can be diagnosed with personality disorders, bipolar disorders, or schizophrenia, and forced into psychiatric institutions to undergo a wide range of other intrusive and violent practices. Another problem is that women with psychosocial disabilities can be discredited or misunderstood when trying to report violence and abuse to the police. We have seen several examples of women trying to report rape or other sexual abuse not being taken seriously if they are perceived to have a psychosocial disability. Instead, they are referred to the mental health system. We have even seen examples of women with psychosocial disabilities being forcibly transferred to mental health facilities right from the police station after reporting violent crimes. A Norwegian case to the UN Special Rapporteur on Torture can serve as an example. A 16-year-old girl had reported a sexual assault to the police, but the case was dismissed by the police authorities. Instead, the young girl was brought to a psychiatric hospital based on perceived psychosocial disability. She was forcibly drugged with neuroleptics and put in solitary confinement. 3 weeks later, she was found lying stiff with her eyes rolling, having severe body cramps, and not being able to speak due to the drug-induced neurological syndrome dystonia, causing painful spasms that can affect any voluntary muscles. She was deprived of liberty and forcibly drugged for years after this. As these violent acts are authorized by domestic law, they are not recognized as acts of violence and ill treatment. Instead of being abolished and prosecuted, such acts go with impunity and official inaction under the guise of care and treatment. Mental health laws and other legislation authorizing psychiatric detention and forced treatment is a severe obstacle to justice and accountability. Women with disabilities having experienced violence also face a number of obstacles in the justice system, including the systematic failure of the courts to acknowledge them as competent witnesses having legal capacity. A Norwegian court case can serve as an example of how badly access to justice can fail for women with psychosocial disabilities. The complainant alleged that she had been raped. She explained in the court that she had been very afraid, that she felt threatened, and that she had not consented. The court concluded that even though there were no doubt that the man had pulled the woman by the hair, hit her in the face, and held her around her neck, it was doubtful that the woman, because of her psychiatric diagnosis, would be able to provide clear enough resistance so that the man would understand that she did not want what he did to her. A perceived psychosocial disability was used as a ground for not convicting the man, and the court sends a signal that you can do what you want to women with disabilities without their consent, especially if the women have difficulties resisting the acts because of impairment or fear. To sum up, violence against women and women's reactions to such violence often becomes an entry point to intrusive and coercive psychiatric measures. Psychiatric diagnosis can take away women's power to name their own experiences, mask violence against women, and create a basis for mental health detention and forced treatment. Law enforcement may dismiss complaints since they see women with psychosocial disabilities as lacking credibility. This creates invisibility and denial of injuries. Together with lack of investigation and prosecution, it leaves women with psychosocial disabilities without effective access to justice after violence and vulnerable to new violence. Such failure in protecting legal capacity and ensuring access to justice also affects women with intellectual disabilities. And then a few closing remarks. As many in this room, I have my own personal experiences with the issues at stake. Forced psychiatric interventions happen to me based on perceived impairment, but also because I am a woman. 20 years ago, I was a mother who had just given birth to my second child. My baby daughter was born with a severe medical condition, and we spent her first 11 weeks in an emergency care unit for newborns. I was coming out of all of this exhausted and in distress. Instead of being met with support relevant to my situation, I was labeled with postpartum depression and forcibly committed to a psychiatric institution. I was ripped out of my life, segregated from my family, including my baby daughter, whom I was breastfeeding at the time, transported by police, handcuffed, locked up behind closed doors, my personal belongings all removed, put in seclusion and isolation, being monitored 24/7 with no privacy, not even in the shower or toilet, forced nudity and threats of forced electroshock. All of this leaving me absolutely devastated by fear and trauma. Behind those closed doors, I experienced violence and human rights violations in many forms, and at the core of all of them is your legal status as inferior, deprived of your legal capacity. Ever since this happened, I have struggled with the same questions. How do we get states to abolish policies and legislative provisions that authorize forced treatment and mental health detention? And how do we achieve abolishment of other disability-based restrictions on legal capacity, like forced abortion and sterilization? I think we need to collect experiences from human rights movements that has come further in achieving equal rights, and that we need to ask for other movements' solidarity and work intersectional with them. How can we learn from other constituencies that has fought the similar battles for human rights before us, like women's movement, fight for equal legal recognition, voting rights, and reproductive rights, the LGBT movement's fight for freedom from medicalization and psychiatric labeling, for legal recognition of gender identity, and for equal marriage rights, from indigenous peoples' fight against forced sterilization, assimilation, and normalization, and for equal legal capacity and self-determination. Disability justice connects with other key movements for justice and liberation from oppression. So how can we build more powerful cross-sectional platforms and gain more allies from other movements and mainstream human rights organizations? Summer School is a good platform for building a community for social and legal change, supporting each other, lifting the spirits of those at the forefront of the disability rights battle, and as was said yesterday, finding our people. I think that is the real power with sharing experiences, ideas, hope, and strength. As was said yesterday, it is hard not to be burned out and feeling guilt for not having finished the job, but at the same time, there are so much progress being made. Especially welcome is the recent Council of Europe Parliamentary Assembly recommendation on ending the detention of socially maladjusted persons, which signals the beginning of the end of targeting people with psychosocial disabilities and other marginalized groups for detention and forced treatments. The way forward is about combating oppression and repealing discriminatory legislative provisions. The paradigm shift will require initiation of fundamental changes of domestic legislation and establishment of mechanisms for reparations. Huge transformations that might seem overwhelming and impossible, but that are urgently needed, achievable, and worth fighting for. And I will end with a quote from Arundhati Roy. Another world is not only possible, she's on her way. On a quiet day, I can hear her breathing. Thank you.
Thank you, Hege. The next speaker is joining us by video link. It is Andrea Parra from Talarista and La Justicia. And she's an attorney, a queer feminist legal activist, experiential trainer, and translator. She holds a law degree from the University of Bogota, an LLM in the American law from Boston University, and admitted to practice in the state of New York and Columbia. And she's worked as a consultant with various human rights organizations at an international and a Colombian level.
Hello, everyone. My name is Andrea Parra. I am based in Bogota, Colombia, and I'm very excited to share with you this space, even though I cannot be in person. I want to first thank an old colleague and friend, Eleanor Flynn. We've been accomplices for a long time. It feels strange to not be in person. I would rather do this live and as an exchange with you all. But I hope to share with you some of the journey intense that's been 10 years in the making, a little more now, for the legal capacity law to happen in Colombia. So I want to share with you today how the law came to be, some of the process, and where we are now today, a bit of it, and I welcome anyone to reach out to me. Since we're not having a dialogue today live, I'm happy to continue it after this presentation. So first, I want to share with you that I co-direct a collective, grassroots collective in Colombia called ALCE. ALCE is the word in Spanish for elk, and in our case, it's also an acronym that means Abolition of Punitive and Confinement Logics. And we started in 2021 as an anti-punitive collective that uses a gender justice framework. My co-director is a trans man, and I'm a queer woman, queer cis woman. And our hope is to center the voice of people with direct experience of psychiatrization and build collective tools outside of the medical system for addressing emotional distress. We have 4 pillars. We have a peer support group, it's called GAM for the acronym in Spanish. We have a Mad People School that is political education for people who've lived psychiatrization. We have a research line, and we also have an advocacy line, which is the one I'm the most involved in. We are a team of 12 folks, and the organization has leadership of people with lived experience. We invite you to follow us on social media. And my work on legal capacity began with other hats. I started working on this as the director of a legal clinic at a university in Bogotá, the Universidad de los Andes. And at the time, when I came in 2011, the conversation about implementation of Article 12 had already begun with my predecessor. And there was a regional alliance with other legal clinics that were working on this. Before the law changed, the civil code in Colombia, which is from 1857, allowed for plenary guardianship, and in 2009, it added partial guardianship. In 2009, it updated the language to not be as ableist, but it maintained guardianship as an institution, as a legal institution. In Colombia, unlike in other countries in Latin America, tens of thousands of people have been placed under guardianship. We don't have an accurate statistic, but we know that in Bogotá only, there are 33 family judges. Each of them had about a docket of 1,500 guardianship cases. So it's a lot. And after Colombia ratified the CRPD in 2011, civil society and an alliance with different organizations like ASAM Colombia and the Autism League and other organizations, also with academia, we started engaging in many different types of actions to push for understanding and implementation of Article 12. And it was with a lot of resistance. I remember presenting in public places and people saying, "What are you talking about? How can you talk against guardianship?" Interdiction is the legal name in Colombia. So there was an international conference that happened in Bogotá in 2010, in which Facundo Chavez was, and other like well-known people in the kind of advocacy at that time. We also engaged in a project that involved revising the route that victims of Colombia's armed conflict had to go through to get reparations. Because what was happening is that if a victim was identified that was entitled to reparation, and that person had a disability, mainly intellectual or psychosocial, the agency was asking for guardianship before they could give them reparation money. So it was the way we discussed it at the time was like repairing a human rights violation with a human rights violation, which of course is not repairing. So we worked on a project to shift that, and out of that, a very important decision from the Constitutional Court came down about the right of victims of the armed conflict with disabilities to make decisions and to exercise legal capacity. There were several cases before the Constitutional Court in which we submitted amici, cases involving sterilization, cases involving denial of the right to education, cases involving domestic violence. It was a case of a woman who was under guardianship, and there was some signs that she was a victim of domestic violence by her husband, and her mother was applying to be the guardian. So the court respected the person's legal capacity by acknowledging that her testimony was crucial to make a determination. We were involved in many community events and community pedagogy with families, with lawyers, with academia, talking about this. We also represented cases trying to get alternatives to interdiction. So even before the law changed, we were thinking of what were other legal venues for people to not be placed under guardianship. One of the main reasons people were placed under guardianship was pensions. There was a belief, even though it didn't have a legal foundation, that to inherit a pension, a person had to be placed under guardianship, because this is what the pension funds would tell people. So we fought that. We submitted a shadow report before the CRPD in 2013, and then other committees talking about how guardianship was a violation of people with disabilities' rights. And we created alliances, key alliances, with the Ministry of Justice and the President's Office on Disability. And then international alliances. Many of you who I have known for many years were part of those conversations. So with all of that background, we created a technical working table that drafted and discussed the bill and met for 3 years to discuss it. And this working table were part, like the Protection Agency, the Ministry of Justice, ombuds people, the General Inspector, the DA. And this was thanks to the President's Office that had that power of convening. After having a bill drafted, we then did advocacy, and now Senator Angelica Lozano championed the bill and co-authored it, also with the Ombudsperson's Office. A first version of the bill had to be withdrawn because in the commission, in the first legislative commission, they didn't want to pass the text, and we found a lot of opposition from liberal parties, with the argument that we were leaving people with disabilities without protection by eliminating guardianship. That was one of the main hurdles in the debate. Then the second version passed all 4 debates, but a lot of my gray hairs I owe to those days, because it passed 1 day before it would have to be filed. In Colombia, if a bill has not been discussed in 2 years, it has to be filed, and then the process needs to start all over. So it passed, and then some talk about the bill started and opposition began, and it took about 3 months for the president to sign the bill into law, and opposition started ramping up. Finally, the law passed on August 26, 2019. And this is a picture of Sergio Araque, who is a self-advocate who testified in Congress about how being placed under guardianship presented multiple barriers to his life. So we had opposition and we had champions in that process. Soon after the law passed, 9 constitutional challenges were filed against it. I was in several spaces where it was very hostile. Lawyers were yelling at me saying they had over 500 cases of guardianship, and it was impossible to change this. It's like, it really shook very structural civil law concepts, and this created a lot of resistance. And the constitutionality of the law was affirmed in every case by the constitutional courts. Now we have good case law. The Ministry of Justice launched a massive training program for over 2,000 officials on the law and how to implement it. Then some civil law attorneys, colleagues, amazing among them, Cecilia Diaz, really took on talking to their field, because there's a lot of resistance from that field, and it has slowed down, fortunately, there were many hostile spaces that we were at. And another key ally was the president of the Supreme Court, who launched a series of, he is a family law attorney, civil law expert, and he launched a series of discussions on the law. And then at the time, many lawyers and judges resisted implementation and the change of paradigm. As to what the law says, the law 1996 of 2019 contains a presumption of full legal capacity and fully eliminates guardianship, total and partial. It does not allow it in any case. It creates support agreements before notaries, mediation centers, and also through a judicial route. It also creates advanced directives as a kind of support. And it creates a service that is a supports assessment, which is not a requirement, except if the case is before a judge, the judge has to request a support assessment as part of the evidence. And if the will or preference of the persons cannot be known, even using all reasonable accommodations, a third party must appear before a judge. So that situation has to happen through the judicial route. And then the law contains a transition section and also mandates judges to revise all the guardianship cases in their jurisdiction by August 26, 2024, which, as you can guess, has not happened. And there's still a lot of cases that need to be revised. And there are all sorts of procedural hurdles for that to happen. So we are at this time discussing what has to happen to extend that deadline. In terms of the implementation, we have 3 high courts: the State Council, which reviews all administrative laws. We have a Supreme Court, which takes on civil, labor, criminal, commercial matters, and we have the Constitutional Court, which takes on constitutional and human rights issues. So both the Constitutional Court and the Supreme Court have issued several decisions. The Supreme Court decisions have clarified a lot of procedural issues around how the law must be implemented. The Constitutional Court has analyzed how the law is constitutional and how it protects the fundamental rights of people. And the Ombudsperson's Office has undertaken the bulk of supports assessments. So a lot of judges order the supports assessment to the Ombudsperson's Office. And in Bogota, by February 2024, according to data they provided, they have done about 4,000 supports assessment processes. After the law passed, it was regulated through 2 decrees. One, regulating the duties of notaries and mediation centers with regards to supports assessment. And then the other one talking about supports assessments themselves and what they should entail. So, and these, actually the supports assessment issue was a tactic and a hope to prevent medicalization of the process of determining what supports a person may request or ask for. Because what happens with people with disabilities is that many people request like the medical history or something like that to determine the supports. So what the supports assessment is an interview that asks about the surroundings, the support network of the person, the wishes they have, what the support assessment is for, what kind of acts, legal acts they want to engage in, to establish what would be the suggested course of action to establish supports for the person. There have been multiple events. We have a coalition of organizations called the Colombian Alliance for Legal Capacity, and you can follow us in social media too. And now it's comprised of civil society, academia, and public officials. Actually, every time I see that, and I see so many voices talking about the law and like such appropriation of the law, I get a little teary because it's something that I hadn't imagined. Like I'll be hearing all these different actors talking with such ownership of the law. It always makes me so excited, which means there has been a cultural shift in the narrative about decision-making by people with disabilities, and now self-advocates and more people with disabilities are talking about this as their own rights. Nevertheless, the implementation has not been an easy ride. Judges and notaries continue to interpret the law and place barriers for its implementation. And too few decisions have been lifted, existing guardianship decisions have been lifted, which are tied to this deadline of August 26, 2024. Also, one thing I would like to mention is I have had the privilege to co-coordinate the Latin American Network on Article 12, and it's comprised of over 150 members from 8 countries where efforts to push for implementation and legal reform to comply with Article 12 have taken place. So if anyone here is from Latin America and would like to join, please send me an email. It's mainly a listserv. We hold meetings, occasional meetings and discussions about specific issues, and also share materials, share knowledge, share strategy. It was basically a place to not feel so alone. And the countries that are part of the network are Argentina, Chile, Brazil, Peru, Colombia, Costa Rica, Guatemala, and Mexico. So these are some of the things that I wanted to share with this. It feels strange not to be engaging in discussion. I would love to hear your questions. I'll be checking the Discord in case you have any conversations you would like to continue. I'm sharing my email and also my social media. And I wish it could be in beautiful Ireland. I wish you the best in the rest of the gathering. I love the summer school as a place for collective thinking. Thank you all, and I hope you have a great rest of the week.
Thank you, Andrea. Next, we have Jennifer Wairimu. She is a litigation officer at the Validity Foundation, an international human rights organization that conducts a range of litigation and advocacy initiatives to promote and advance the rights of persons with intellectual and psychosocial disabilities. She is currently based in Nairobi in Kenya, and her work focuses on drafting legal submissions in human rights situations, conducting research analysis on laws and policies at a national, regional level on the rights of persons with intellectual and psychosocial disabilities. Thank you, Jennifer.
Good morning, everyone. Thank you, Ruth, for the introduction, and thank you, Hege, for your wonderful presentation, as well as Andrea for sharing the experiences in Colombia. So my presentation is meant to address how criminal justice system and legal capacity for women with intellectual and psycho... Am I not audible? Louder? Okay, I'm sorry for that. So my should I start from the beginning? Oh, this is fine. Good. Okay, thank you. So my presentation just discusses criminal justice system and legal capacity for women with intellectual disabilities. And I will not only but mention the laws that have been mentioned by Hege and Andrea somewhat, but will also capture the experiences that we've had in our work. As mentioned in the introduction, we do have present cases ongoing that are very particular on this particular subject, and I will, in my presentation, discuss the different violations that happened and how we can actually relate that to this. So with no further ado, and not but to retaliate the definition on legal capacity as had been captured by the earlier speakers, I want to highlight the fact that the general comment number 1 by the CRPD committee and how it emphasizes that legal capacity includes the capacity to hold rights and act under the law And I think it will be a disservice if we don't mention that the international principles and guidelines on access to justice for persons with disabilities have also comprehensively defined legal capacity, and this is very key to the conversations we are having on legal capacity. And that leads to indicating and showing that denial of legal capacity, which is a violation of Article 12, is a key element on how criminal justice system fails to recognize legal capacity of women with disabilities, and more so on equal basis with others. And in particular, the denial of this legal capacity on both civil and criminal legal processes is actually a common and fundamental obstacle in ensuring equal and non-discriminatory process to access to justice across the world, as has been captured by Andrea in Colombia and Hege when she mentioned the cases from the Norwegian cases. So I think we can all see collectively that this is an approach and challenges that is felt across the world. And apart from it being a denial, it's important to indicate and communicate that women with disabilities tend to face forms of discrimination and exclusion which can impede their access to justice while in the criminal justice system. And this more so continues on the discrimination on the basis of disability, which remains to be one of these many forms. And I think we can all appreciate that this is a challenge that we have all over. And I will go now into the discussion on some of the systematic challenges faced by women with intellectual and psychosocial disabilities from a background on what our organization, our Validity Foundation, does. And we can clearly see that some of the challenges tend to include but outdated laws which do not recognize their legal capacity, and consequently there is the denial to the right to stand in a trial and provide testimonies. You'll actually probably correlate this with the presentations going forward and probably later in the day. There's also the issue on lack of procedural accommodations that is very, it's key to indicate, and there is also the omission to detect disability and provide the said procedural accommodations. And then another challenge is the stereotypes associated with disability. And I think from the conversations that we had from day one, yesterday, and today, it just built up to some of the discrimination that is usually undergone in the different jurisdictions. So apart from mentioning the CRPD, which I think is one of the key, it's the instrument that we are relying on, I would want to bring that to our attention that the protocol to the African Charter on Human and People's Rights relating to the rights of persons with disabilities in Africa, it actually came in force on 3rd of May 2024, last month, following ratifications by 15 countries. And this holds importance for the domestication and implementation of legal capacity in African states, whose circumstances can be quite different sometimes from situations in developed countries. Therefore, this particular protocol it's a welcomed instrument in Africa, and particularly it provides in Article 7, which establishes the state obligations on legal capacity. It frames important contextual continental distinctions on the exercise of legal capacity. It also asserts the equality of persons with disabilities before and under the law and their entitlement without discrimination to the equal protection and benefit of the law. The said Article 7 as well has established further or more nuanced state obligations for ensuring the legal capacity of persons with disabilities, and it has indicated 3 key issues that states must ensure, and these include that non-state actors and other individuals do not violate the right to exercise legal capacity by persons with disabilities. The second one is policies and laws which have the purpose or effect of limiting or restricting the enjoyment of legal capacity by persons with disabilities are reviewed or repealed. And I think there's that correlation on the discussion that has been done by Andrea on laws that actually need to be repealed with time. And then thirdly, there's the persons with disabilities have the equal right to hold documents of identity and other documents that may enable them to exercise their right to legal capacity. So it will be a disservice not to mention that as much as it's a regional document and also an international document in a say, that the national legal frameworks that we have in Africa, most of them, the constitutions do not include nor guarantee on the legal capacity of persons with disabilities, whereby they tend to have general provisions guaranteeing every person equality before the law, equal protection of the law, and equal benefit of the law, or prohibiting discrimination. And the state constitutions tend to establish that rights for all on one hand, and then on the other hand, they tend to probably take these rights away from persons by the statutes that we have in place. And sometimes in the statutes, which are not in correlation with the constitutions, tend to refer to persons with psychosocial disabilities and intellectual disabilities as persons of unsound mind, which are some of the key issues in terms of repealing laws and policies that need to be addressed. Then also it will be good to add on that criminal and civil codes in most of the African countries tend to continue to use language and negate the humanity and personhood of persons with psychosocial or intellectual disabilities. And therefore, with the ratification of the African Disability Protocol, we definitely are hopeful that some of these laws will actually be repealed and therefore can be of use when it comes to litigating further in terms of the legal framework and setting precedents. So as mentioned, I'm from Nairobi, Kenya, and I wanted to just slightly touch that there's a study which has captured barriers that limit persons with intellectual disabilities in criminal justice systems. And this study was conducted several years ago, and it captures that persons with intellectual disabilities did not receive procedural accommodations to equally participate in criminal justice processes as victims of crime. And this happened both at the police station and the court. Questions were often asked in complex and technical language, and adjustments or adoptions were not made in communicating the notion of time, quantity, dates, or place, which is a huge challenge. The other barrier that was also captured is the negative attitudes and assumptions often resulted in persons with intellectual disabilities being viewed as unreliable, lacking credibility, and being incapable of giving evidence or otherwise participating in criminal justice systems. Their testimonies at this point were deemed intrinsically less reliable or lower quality, therefore they were not at all considered in the proceedings. Then also another barrier is that key actors in the criminal justice system, including the police, prosecutors, and magistrates, had limited understanding of intellectual disability, particularly in relation to the impact on adducing evidence and other aspects of participating in the criminal justice system. These actors in the justice system often fail to identify that the manner in which the justice system was set up, it's negatively impacting on victims of crime who had intellectual disabilities. And lastly, the study also captured that delays in criminal justice proceedings presented a unique challenge for persons with intellectual disabilities who may have had difficulty recalling information and sequence events over a longer period of time. Now, I would like us to reflect on 4 cases, and these particular cases are more or less ongoing, and they touch on a number of violations. There is the first case, and these are cases from one of the countries that we work in Uganda, and it would, I believe, based on the conversations we are having today, and as presented by the former speakers, they indicate the intersectionality and also the same challenges happening across different parts of the continent and the world as well. So we have the first case, the said particular woman, we can give her the initials ABM, was diagnosed with schizophrenia and was abandoned and raised by an adoptive family. So when she was 15, she was found to be pregnant. And then 3 months after the birth of her first child, she was also pregnant again. and her babies were placed at an orphanage because of the perceived psychosocial disability. And also on the perception that based on her condition, she cannot take care of her children. Currently, she has 3 children. She was never offered any social support services after she suffered sexual violence in the community. There was also no effective investigation into the sexual violence, and this has come across earlier on. And then I should mention that to this date, neither her nor her guardian have received any information that she can understand on her own in terms of her sexual reproductive rights and also on her personhood and the right to family. And therefore, the legal issues in this particular case as captured were the fact that the removal of her children without considering her ability to parent with support violates her right to family. Then there was the whole issue on right to health and information, whereby the lack of psychosocial support and accessible information on her sexual and reproductive health rights contravenes, of course, Articles 12 and 25 of the CRPD. And lastly, community support services, whereby the denial of these infringes upon Articles 19 and 26 of the CRPD. So the second case, this was slightly similar in the sense that the woman in question was diagnosed with bipolar sometime in 2016, and during her admission at a mental health unit in that said country, she inadvertently wandered outside the hospital premises and was sexually assaulted by a stranger. After managing to find her way back to the hospital, she was discharged without undergoing necessary tests for HIV and STDs, and there was no effective investigation. And also, her claims were never taken seriously, regardless of them trying to ensure that justice is sought. Following the traumatic incident, she received no social support services in her community, and it has, since the incident happened in 2016 up to date, there is nothing that has happened to her. There's no support that has been provided to her. So you can see the intensity on lack of some of these services that should be available. The third case, this particular woman was fetching water near a construction site in a company, in a construction site in company of her friend. And unfortunately, they were drugged and raped by persons known to them. And before the ordeal, she had no mental health issues. But afterwards, she was diagnosed with PTSD after the sexual violence. And the hospital she went to for treatment never gave her any counseling or rehabilitation services. Neither did the hospital follow up on health status once she was discharged. And you can clearly see that the legal issues in that particular case, aside from freedom from inhumane treatment, because of the neglect on her post-assault care, that was never addressed, and this is what we are trying to mitigate on. There was also the right to health and rehabilitation, whereby the hospital's failure to provide the mental health support and follow-up clearly is a violation of her rights, but they have not taken any action. And then lastly, the fourth case, so this case was on a woman who was sexually assaulted by a security guard while she was admitted at a referral mental hospital. She was denied immediate medical care, psychosocial support, just like the other 3 cases. And also there was no support to address the trauma that she underwent. Now, this particular matter was dismissed at the High Court, unfortunately, earlier this year. And while the judge was dismissing this particular case, he alluded that there was lack of enough evidence to support this particular case. And then also the ruling captured a couple of issues which are very pertinent. There was a lot of gender biasness in the reading of the said ruling. There was also the issue of victim shaming. And apart from that, there is the continuous show that indeed the judiciary was not engaged at all with the concept of disability and gender-based violence. And also this case actually captured the credibility of evidence from women with psychosocial disabilities and how it's usually questioned. And I think this has been captured by one of our former speakers. And I believe this might have been Hege and the lady from Colombia. So as an organization, the strategic goals with these particular ways of litigation, one, it's to ensure that we hold the government accountable and demonstrate that the state's failure to protect the rights of women with psychosocial disabilities and therefore demand for accountability on the SGBV. Then the second goal that we have with these litigation activities is to ensure redress and protection, and as well as advocate for appropriate redress mechanism and protective measures to be put in place within the health system and community services. As I've mentioned in the 4 cases, it's very clear that there was no health services that was provided for these women, and therefore that remains to be a big challenge. Then the issue of effective investigation. This is very key in that we are trying to ensure that the claims of SGBV made by these particular women are always effectively investigated in an appropriately sensitive fashion. Now, it cuts across on the 4 cases. As I was informing you of the little nitty-gritties of the cases, none of them touches on any investigation that was carried out. And this is a very big slacking from the state, and hence the need to ensure that the litigation will address some of these issues and hopefully positive precedents can be developed from it. Then also another goal is on international obligations. So we are highlighting the obligations under the country, under the international standards such as the CRPD and other human rights treaties, to ensure comprehensive protection and support for women with psychosocial disabilities, and push, particularly in this case, the Ugandan government to introduce sufficient range of appropriate community-based support services. And then, based on the ruling that I've mentioned in the last case, it is very clear that there is the need for awareness and training. And then there needs to be a huge push for training judicial officers as well as health system personnel on the rights and needs of women with psychosocial disabilities to prevent discrimination, bias, and improve the support that is offered. As we can see, there was discrimination not only in the courts, the corridors of justice, but there was also discrimination and neglect at the health services, whereby these are 2 areas where these women were sort of seeking their rights to be addressed, and this was literally neglected. So we can clearly see that different systems need to work together to ensure that obligations are met. Now, apart from all that I've said, and in conclusion, and as a reflection of the 3 cases, it is good that my former colleagues spoke before me, because it has brought in the different experiences that have been held in different countries. There is the experience from Kenya, there is the experience from Uganda, another country neighboring Kenya, there is the experience from the Norwegian cases, there is the experience from Colombia, and all of them reflect and show that the denial of legal capacity for women with disabilities remains a critical barrier to access justice. Now, these cases collectively aim to address systemic issues in all the different countries, and treatment of women with psychosocial disabilities seeking justice and accountability, and to prevent further violations, shows that there is the need to continuously continue litigating, and the efforts on realization on legal capacity can lead to creation of precedents that will see the implementation of laws, as well as the different states meeting their obligations as stipulated by the CRPD and the different regional instruments that we have in place. That is all I had for you this morning. Thank you so much for listening to me.
Thank you, Jennifer. I'd like to invite our final speaker on the panel. It's Professor Anna Einstein-Kerslake, and she's a leader in the fields of human rights, disability rights, gender justice, and legal personhood. She has published including sole-authored books, Restoring Voice to People and Legal Capacity and Gender, and she was Programme Director of the LLM in International Human Rights Law here at the Irish Centre for Human Rights. Thank you.
Thank you very much. I'm so privileged to be on this panel today with these wonderful women that have given you so much valuable information in the space of legal capacity, and in particular how gender is related to legal capacity. Thank you. I think it actually is perfect that I'm last, because what I want to talk to you about is both the practice and the theory when it comes to how legal capacity applies to gender. So I want to start with a brief story for you that I have had gotten permission to share with you. And then I want to talk to you a bit about my research and the law and theory around legal capacity and the right to legal capacity, and how it applies in the context of gender, or perhaps where the gaps are as well in the context of gender. As was mentioned, I am currently a professor here at the University of Galway in the Irish Centre for Human Rights, but I started my academic career actually here at the Centre for Disability Law and Policy, where I did my PhD in from 2010 to 2014. 2011 to 2014. So I'm also really happy to be back presenting at the summer school, which I haven't done for several years because I've been down at the University of Melbourne, where I actually have a joint lectureship now. So now I'm just jetting around the world between my various posts. The story that I want to share with you it's related to the origin of why I have gotten into this work and why I've gone into the area of gender justice and disability justice, and more specifically legal capacity, which I think perhaps will be obvious to you as I continue. So it's really only a small story. There's a much larger story, but I think this story might help give you more context, and it also relates, and there's lots of parallels to the cases that were talked about previously, especially in Jennifer's presentation and Hege's presentation as well. So my sister was born with Prader-Willi syndrome. Maybe some of you are familiar with it. It's a difference in chromosome 15, and it can manifest characteristics which include really low muscle tone, a very low amount of the hormones that tell us when we're full, so high levels of hunger all the time, as well as intellectual disability and mental health disability. My sister has hit the jackpot with Prader-Willi syndrome and has all of those characteristics, and she's 2 years younger than me. So we really grew up together in California. You can probably tell. Yeah, not Irish. As we were growing up, in many ways, our lives were very parallel. We had really similar milestones. In fact, Sarah kissed a boy before I did, even though she was 2 years younger than me. So we really were very close and very well aligned in our development in many ways. When I left for university, I was 18, and I went to a university that was quite far away, so I wasn't living with my family, and Sarah was still at home finishing high school. I got a phone call in my second year of university, so I'd been away for about 1.5 years, with several visits home, but living away. And what Sarah told me on the phone at that time, conference call with my mother, because conference calling was something we did back then, was that 6 months prior to that, over a summer period of at least 6 weeks, but we think it may have been longer, she was sexually assaulted in a series of events. And we're not 100% clear whether rape occurred or not, but definitely sexual assault. And it was another student that was involved, that perpetrated the sexual assault, a male student, and it was at a segregated special education summer school because in California, in Sacramento, where we grew up, at the time there was no, the summer schools that were available were only segregated. They didn't welcome students with disabilities into the mainstream summer schools. So it was a segregated summer school program, and Sarah had been acting very strange for the 6 months prior to this phone call, which turns out was seems to be directly related to this ongoing sexual assault that she experienced. Prior to this, Sarah had one boyfriend that she saw very consistently. He actually had more than one girlfriend, but that only came out later. It's in the normal course of relationship events when you're a 15, 16-year-old. And they had broken up, and Sarah was in this summer school where this other student took her into a bathroom setting. And again, it's unclear exactly, but definitely sexual assault occurred over these 6 weeks. Now, there's a lot of things I could tell you about this story. I think one of the most important things, perhaps, is that immediately when Sarah understood what happened, and she only understood what happened because she had what was her first sexual education class in those 6 months after it happened, when she was 16 years old. And we didn't realize, but she'd actually been excluded from the sexual education classes because she is a woman with disabilities, a person with disabilities, and she'd been excluded from them in previous years. So perhaps someone forgot to exclude her when she was 16. I don't know what happened there. And she finally understood that what had occurred was sexual assault and was inappropriate, and something could be done about it. Once she was able to vocalize that and share that experience, we supported her in immediately contacting the appropriate representatives in the school, in the law enforcement, and indeed in the prosecutor's office as well, through a process. Ultimately, the decision was made that Sarah wasn't an appropriate person to be able to give testimony in a courtroom setting or in any legal setting. And no charges were brought forward. Nothing happened to the individual. And we later came to find out that this person had moved from school to school because he had been perpetrating a series of sexual assaults against, as far as I know, all women with disabilities in various special education settings across the city. And as far as I know, nothing happened. What did happen to my sister was the onset of mental health disability, which many health professionals attributed to her disability, but which directly coincided with her experience of sexual assault. And I think it's a disservice to say that her mental health disability was a result simply of her Prader-Willi syndrome. I think there's a clear connection. So you can imagine. So there's a clear legal capacity denial here, which is at the minimum a unique experience on the basis of gender in the context of her not being able to give testimony or not being even allowed the opportunity to give testimony. But there was, you can imagine, and has been and continues to be an ongoing series of legal capacity denials that have been sort of has a snowball effect, if you will, in relation to all of these experiences that occurred many, many years ago now. Now, that's to give you a background of why I was interested in this. And I've taken up most of my time presenting here because I actually think that's the most important thing. The stories of all of the women and gender minorities that are disproportionately and uniquely impacted by denials of legal capacity. I think that's the most important thing we could possibly talk about. And there's so many of them. And some of them sound like and look like the story of my sister, but many of them look different and are in and different areas of the law are impacted. So my research started sort of in this broad space of looking at what is legal capacity, where is it denied, and especially in the context of disability. And that's where a lot of my early publications lie, many of them co-authored with Eleanor Flynn, of course. And then as I continued my work, I kept thinking back on my sister's experiences and my family's experiences. And it bothered me, and it still bothers me, that so many of these denials are gendered denials of legal capacity. And that I almost had the feeling that we were looking at legal capacity in the same way we look at law in so many different spaces, taking a male as the example, as the sort of basis on which we're looking at how can we apply the law. And I think we're always making an error when we're doing that, but I think we're definitely making an error when we're doing that in the context of legal capacity, because in fact, it's women and disabled women and gender minorities who have experienced by far the most profound denials of legal capacity throughout history, and I would argue now as well. Now, just to say really briefly, if you're interested in some of my research that I've begun to undertake in this space, and I really think both the scholarship and the litigation, as Jennifer began to tell us about, I think it's really in its infancy. I think we're actually only beginning to fully understand first what a right to legal capacity is, and then the many and varied ways it's denied to women, disabled women, and gender minorities and disabled gender minorities. So in 2021, in the midst of COVID, and right after I had my second child as well, I wrote and published this book on legal capacity and gender. And what I do in the book is look at the history of how women, disabled women, and gender minorities have been pathologized, and their cognition has been devalued. So in the context of women, I look at the myth of hysteria, which was definitely mentioned by Hege as well, and perhaps Jennifer as well. And maybe Andrea as well. I definitely heard it a few times there. So the idea that the female brain lacks rationality, I mean, and it goes back to some really interesting, perhaps strange, and definitely concerning ancient Greek ideas of female reproductive organs creating madness. And we can see these threads of this kind of understanding of female decision making in our laws today as well. We definitely can see a lack of respect, both formally and informally, globally. I don't think there's any jurisdiction that is free of this, or that has overcome this. We can see a lack of respect for the cognition and decision-making skills of women in general. And then, of course, in the context of disabled women, you also have the myth of incapacity. So the myth, which is what I call it in the book, the myth that a disabled woman has somehow less or more impaired decision-making skills than others, than other women, than other people. And I go through a variety of ways in which that is, of course, inaccurate. And then I look at the myth of illness in the context of gender minorities. And that's happened in the context of transgender people, transsexual people, intersex people, and others that don't identify with or biologically fit into the gender binary that is so pervasive throughout our societies. The idea that there's an illness attached to that experience, and that illness then again is a reason to devalue the cognition and decision-making of people in that group. So I go through that history, and then I look at how that history has and is impacting our current socio-legal systems, and how women's rationality and decision-making skills continue to be devalued throughout health and medical systems, for example, but also through financial systems. I think it's really important to note that coverture laws, so laws that removed the legal capacity of women upon marriage, those were only gotten rid of in the United States, for example, in the 1970s, like the 1970s. And there's many countries that they still exist. And I think we often forget that. We forget how recent it happened in some places and how it's ongoing in others. You know, I mean, that's as simple as opening a bank account is a huge barrier for many people to exercise their legal capacity in that context. It's a barrier simply on the basis of gender. And then, of course, you have the added layer of discrimination and barriers in the context of disability for disabled women. So the list and examples go on. And again, my fellow panelists, I think all three of them also provided some really good examples. And I've listed many of them as well in the book, and it's by no means exhaustive. In fact, I would say the book probably represents, I don't know, 10% of the ways in which women, disabled women, gender minorities, and disabled gender minorities are experiencing denials of legal capacity, either on the basis of gender or uniquely because of gender. I really, and then I do cover also the marginalization and vulnerability that's created by those increased denials of legal capacity. I think what I would like maybe the takeaway to be is just that we have so much work to do in this space. And I think that was perhaps a message from my panelists as well, my fellow panelists as well, that it's so wonderful, I think, that now an understanding that there is a right to legal capacity is relatively, I mean, mainstream in the context of a relatively small human rights community. But still, I mean, we can see, as Andrea talked about, that there are real legislative changes occurring. And I think there is a willingness for change in the space of realizing the right to legal capacity. And what I want to make sure that we do is not realize a right to legal capacity in the same way we've realized many other rights within our patriarchal society that is dominated still by mostly white, able-bodied men in positions of power. Let's not let this right be hijacked. Let's make sure that we're looking at how these denials are occurring, who they're occurring for, and the ways in which they're occurring, and the ways they're occurring uniquely for certain groups, and especially in the context of gender. Thank you very much, and I'm looking forward to all of your questions.